I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today is going to be our 45th compilation. That's right, number 45 when it comes to our compilations here on the channel of the past proceedings that we've shared here on the channel. We are headed to number 50, and it would not be possible if it weren't for you guys. Today, for number 45, we're going to be in 3 different judges' courtrooms, but they're all going to be out of the state of Michigan. There will be no commentary at the end of this video. Chapters will be added to this video. And with that being said, let me give you the rundown of these Michigan judges. First, we will be in the courtroom of Judge Erane Washington. Second, we will be in the courtroom of Judge Elizabeth Disanto. And last, we will be in the courtroom of Judge Taylor. So today we got some of the women judges handling their business. For many of you that have not seen these, I know you're excited to also see what the sovereign citizens in these cases had to say. So with that being said, guys, let me get out of the way and let's jump into number 45.
Country Meadows versus Tariq Samar Day and Erica Witherspoon. Case number 23C0276.
Christopher Borkin for the plaintiff.
Tariq Samar Tariq Day.
Thank you. Mr. Day, did you serve this notice to principal? Is notice to agent, is notice to principal, administrative procedure motion that you filed with Mr. Borkin?
It was a.
Sir, my question was simple. Did you file it with Mr. Borkin?
I don't believe so.
You have to file anything you file with this court with Mr. Borkin and opposing counsel, or is considered not filed. That's the court rule for any court.
Oh, okay. I must have missed that.
So he filed something called affidavit of high prerogative writ of quo
Pro warranto. Yes, ma'am.
It's not something that gets filed in the district court anyway, but he did file that, and I presume he's going to file that with you.
Thank you, Your Honor.
I will do that.
Your Honor, my client is here to chime in. If it's necessary to take testimony.
I'm not even sure what this document is. He is filing something here that he wants a fraud of false claims for $30,000, conspiracy $250,000, failure to respond $1 million, failure to respond as outlined $1 million, summons to the court, which you can't do. I'm not even sure what any of that means. Responsive communications $250 a page, and then $2,313,500 for review and research of responsive communications at $500 an hour, but he says it's 8 hours.
The property was put into trust as a trust property, and the subject matter of the trust is the subject matter of this case is under the trust. The case number, account number has been conveyed to trust as well. And I was seeking to have this matter handled with equity.
Mr. Day, I'm seriously becoming very concerned about your mental capacities, which is a very unique situation to have to deal with in a civil case.
I'm not sure what to say to that. Ultimately, if just seeking for the plaintiff to provide that the original negotiable instrument wasn't securitized, because if it was invested or securitized, it means that it should be discharged.
Mr. Borkin, do you have a response to whatever
I would focus on the complaint that we filed, which was for non-payment of rent. I would indicate that there's still an amount of rent owed to date.
Mr. Barton, I fully understand that. However, at this point in time, the court just indicated that I have some concerns about his mental capacity as to whether or not he should be trying to represent himself in a court of law at this time. Because I don't think that he fully understands what's happening here today. So I'm not going to proceed unless I feel like he fully understands what's happening, which is a problem.
Your Honor, I believe there's another defendant on the complaint. I don't know if they're present today.
Is Miss Erica Weatherspoon present with you?
No, she's not. She's currently 9 months pregnant.
All right. First of all, Mr. Borkin, I'm not willing to move forward on this today. I have to do several things. One is I want him to file with you the motion that he filed with this court. So that needs to go to you. Two, I need to research how to do a referral in a civil case. If that can be done in a landlord-tenant case so that he fully understands what's happening, because I don't think he understands the proceedings that are going on right now. And then three, I'm going to refer him to speak with someone at legal services so that I can at least feel like he's had that ability to communicate with someone. If he doesn't do that, then that's a whole separate subject. Because then maybe I can at least justify moving forward with where we are right now. But at this point, I am not comfortable moving forward.
Your Honor, I would provide my email address, and he could send his motion to my email if that's easier.
Thank you. Mr. Day, are you able to?
Yes, ma'am.
Are you able to determine, are you able to see what's in the chat feature, sir?
I think,
Do you know how to get to chat?
no, ma'am. I'm
All
sorry.
right. What you're gonna need to do is look on your phone. Do you see three dots at the top of your phone that say more?
I'm currently on a laptop.
Oh, okay. So look at the bottom of your
Okay.
screen. Do you see where it says chat? You see something in red at the bottom that says 32 or 33?
I do see chat.
All right. Click on that and you should see his contact information in there. You need to file this notice, motion, whatever you call it, with him. Okay, so that's first step. Two, you need to I'm referring you over to legal services so that you can talk to them about the nature of these proceedings so that you fully understand them. Okay.
Okay.
And that is they have hours between 10 and 11:30 on Tuesdays, and then 2 and 3:30 on Thursday. Okay.
Okay.
And then I believe the last thing I said was once you've served them with that motion, I'm going to look into whether or not there's the ability to refer for competency, and I'll have that answer when we come back here next week. I'm going to adjourn it over for 1 week to see where we are with all of this.
Am I not able to ask for a jury trial? Is that a different process?
You can ask for a jury trial. There'll also be an escrow where you have to put your money in escrow until that time comes.
Oh, okay. Is that escrow? Is that is that something that you all provide?
You have to come to the court and put your money into play it here at the courthouse, sir.
Okay.
And you have to file the proper demand for a jury trial. That's probably why you need legal counsel.
Okay.
Okay. So how much is the rent per month?
Are you asking me, ma'am?
No, I'm asking Mr. Borkin.
Okay. Sorry.
My complaint indicates that monthly rent is $1,083.
$1,083. So that's how much you'll need to be placing in the escrow until the trial happens, okay, sir?
Okay. Is because I think my partner, she completed something with Michigan Bridges to maybe get some kind of extension or help or something financially.
That may be true, but if you request a jury trial, you have to put your money in escrow. If you don't, then you waive your right to that jury trial.
Okay.
Okay? That's why I'm telling you to go over and talk to legal services.
Yes, ma'am. Yep.
All right, so I'm gonna bring you all back here on March 15th. You need to serve him with that document, okay?
Yep. Yes.
And then I'll see you here on March 15th. I'm gonna schedule this at 3:30,
3:30.
okay?
Thank you, Your Honor.
You're welcome.
Okay. Thank you.
You're welcome.
For the people, please. Ms. Bella? Ms. Bella, can you please place your appearance on the record? Ms. Bella? Okay, counsel, your Mr. Pervin Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
So you're all right. So counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right. The court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just a
recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Okay, yeah, I request that. Also, I request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
okay, hold on, just one moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. All right, and so, okay, that's what this one is, that, okay, so this seems to be, so the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one, okay. So let me make a note on here. So I'm just going to note defendant's motion for Zoom transcript denied as it doesn't, Zoom video denied as it does not exist. Right, because you did that on, you recorded that, right, Ally?
On the 7th?
Yes.
I believe so, but I don't know. I have something from the 7th, but I can't click it while I'm recording.
Yeah, no, I think you came in to record on that day. Okay, so I just wanted to confirm that that was in fact done with Ally, so we have the transcript only for that. Okay, and so then you filed something, let's say I see something else on January 21st. Oh, this must be the copy of the same.
They'll give you 2 copies of each.
Yes, yeah, okay, that's fine, okay, so there's that. You filed something on January 17th, and you're requesting our 2.003 to dismiss, disqualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at city of Winnebago public schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional rights.
Okay,
Now,
sir,
and I believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive somebody with assault and battery or domestic violence. They're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir,
I'm with you.
The allegation is that you assaulted, resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah,
Okay,
you need
so
to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
okay.
But none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of my own. If I followed your white laws, I follow them, and then you stomp on me when I follow your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now.
You
I'm
violated
not
our
100 years
rights.
old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay. Yeah, it don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
No.
took an oath to uphold every citizen's constitutional right to public protest, but
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right. So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did.
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your
So
schools
I don't
and
have
your wind
arrest
out,
warrants.
when I
Sir,
go to schools and your wind out, you should arrest me. But
Sir,
you're not going to. It's
I
my
do
right.
not, let me just clarify. I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no, no, no. There's allegations against you that you did this, this, and this. I'm trying to tell you I exercised my constitutional rights and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment, please. This court, sir, has to take the allegations and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know
I'm
what
15.
roads of mine you've been down, sir.
I'm 15,
But you've
the
been here,
defendant-
excuse me, you've been here in this court a number of times,
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you've even stated that
That's
yourself.
not all entirely true.
Hold on, sir, I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir, I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postpone. The City of
that
Woodhaven
the
wrote
federal
violation. No, they wrote violations, for posted signs in this case, in other cases. Because I was protesting in the City of Woodhaven.
Okay.
But on the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid, I'm not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year.
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid. I made sure that there was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway, I'm
That's
15. I'm 15. The defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way, it's impartial. It's where another judge can look at it and not just yourself. And apparently, you want to hold this case for a reason. And I believe that you in the City of Woodhaven, the state of Michigan is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, there's something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the City of Woodhaven because of allegations that I committed assault against the police officer. You guys don't even know me.
Sir, okay, stop right there, please, just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I am obligated, whether I want to or not, to sit and preside over the matter. I am the chief judge of this court, and so I don't find that there's a basis at this point for me to disqualify myself. However, you certainly have the right to request the State Court Administrative Office can review that. That is absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this because if you don't want to dismiss yourself from this case, we got a problem right there. Because
There's not a problem, sir. I have a responsibility.
The city would have.
Sir, I have a responsibility. The matter is transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here, I don't know. I can ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So,
I have
just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the city of Woodhaven. I think the judge Ken Bash or something like that, he might be up there somewhere. He's retired now. You guys did me the same thing, same way you did.
You guys, I wasn't here.
Well, that's what I'm trying to say. Your system, you wasn't here, you're not 100 years old.
It's not my system. It's the system of the country. It's the entire system. You keep accusing this court that I'm 100 years old and I've been oppressing things for 100 years, that it's my system.
Well, I'm saying
I didn't arrest you. That is not
it's your system.
my system.
And regardless, this is your system. It's not mine.
It is yours. It's
No, it's not. I'm Native Indian African. I'm not even a citizen.
No?
No, I'm a prisoner in my own country because of you white people. Y'all need to go back home where you guys come from.
Okay, sir. Well, let me just say this. All right. You are accusing this court of being biased and prejudiced.
And racist.
Yep. And racist. However, your comment, sir, would seem to suggest otherwise.
Look, why do you raped us, you robbed us, and you murdered us legally?
Stop right there.
Everything that you people have done has been legal.
There. It's not you. I did not do that.
You're the system.
Do not put that on me. But here's what I'm going to do, sir. I'm going to grant your request. And this court's going to disqualify itself, and you can figure out which other court's going to handle this matter. After the state court administrative sends wherever it's got to send, whatever it has to send. Because at this point, I am not going to stay here, take the abuse from you and your allegations, which are completely false and unbased. This court, myself, did not do anything that you're accusing me of doing at all. I wasn't even around at that point. So we're going off the record. You can step outside in the lobby. Somebody will give you the next stuff you have to do.
And I'll give you a call, Mr. Kelly. Thank you very much for helping me.
That's all.
Yes.
There'll be another judge assigned.
So am I free to leave, or do I got to get paperwork or something?
I believe that you're all set, sir.
Well, thank you. You have a good weekend and a good year. Thank you.
Good luck to you, sir.
I don't want to violate none of you guys' laws. Heaven forbid.
Okay, I have to wait to write this file. All right, counsel, so there's that. So it won't be this court anymore.
Okay, Judge. I appreciate the judge granting my withdrawal. I will contact and make sure that counsel is appointed to Mr. Peterson if he wants it. But otherwise, thank you very much, Judge. Have a pleasant day, and I'm sorry it had to be this way.
Oh, you're all set. Thank you. Have a good day.
You too.
All right. Now calling the matters of the people versus Timothy Talley Williams. This is ticket SP. I'm gonna just call his ticket numbers. Ticket SP 146680, count 1, 2, and 3. Ticket SP 1467130, count 1. Ticket SP 1283889, count 1. Ticket SP 145230, counts 1, 2, and 3. Ticket SP 1283888, counts 1, 2, and 3. Ticket SP 1411848, counts 1, 2, and 3. Ticket SP 141840, counts 1, 2, and 3. Ticket SX 2454328, counts 1 and 2. Ticket SP 1409983, count 1. Ticket SP 1409982, counts 1 and 2. Appearances for the record, starting with Mr. Williams, who's representing himself. It's okay, Attorney Vinik. He's representing himself.
Thank you.
You're welcome. All right, Mr. Williams, can you state your name for the record, please?
Timothy for the record, here by special visitation.
All right, and this is the date and time set for a final pretrial in this matter. We are scheduled for a jury trial on Monday, Attorney Mason has tendered to the court a witness list in this matter, as well as a special jury instruction, sir, for you to be able to see in this particular matter. And let me ask again for the record, you know, you have the right to have an attorney. Would you like to have an attorney for you in these matters, sir?
Well, for the record, I'm here to serve a default judgment. I served you, Andy Mason, the affidavit back.
You did, and I'm in receipt. Oh, go ahead. I didn't mean to cut you off. Keep going.
Yes, on the first, and I gave you 15 days, all in, it was 23 days I gave you, and I haven't received a rebuttal. So I served you guys with a default, and I'm here to
I don't know what a default is. So there's no default judgments in criminal matters. These are criminal matters. So the only default that we have is if you don't appear to answer for a ticket, then the default that goes into place is your failure to answer for a ticket. Once it's established and it's here, I don't have to establish why these are tickets on the docket. That's why they have the jury and the bench trial options for you. These have been matters that have been, unless there's been a motion about a formally written motion about illegal stop or some constitutional violation, these tickets are considered to be valid and true.
No, I answered an affidavit of non-corporate existence.
So Mr. Williams, the answer to the question today is whether you're going to trial on Monday or not. That's all I'm here for.
Well, you guys haven't rebutted my affidavit.
Mr. Williams, again, I'm gonna say, Mr. Williams, again, the question for today is whether you're going to trial on Monday or not. That's all. I have officers present. I have officers Evans present. I have Officer McCree present. I don't know if Officer Bush is coming as well, but they are here today to know whether or not they're going to be ready for trial on Monday. We set this jury trial out a long time ago for this trial on Monday. So are we going to trial?
Officers? What officer?
We have Officer Evans and Officer McCree present today.
And Judge, I have Officer Nunley. He's trying to check in right now. Faison Nunley.
Officer Bush is here also.
Thank you, Officer Bush. I didn't see. Good morning. Oh, it's Evans Williams. Okay, say thank you, Officer Bush.
Okay, we go to trial.
Okay, so Monday we go to trial. Do you have a witness list or no, it's just you, Mr. Williams?
Yes, I have 3 witnesses.
Okay, I need to know their names. They need to be provided to counsel. So you have to write them down and do a witness list.
Okay.
Mr. Williams, can you just email me that? We've been emailing, Your Honor. He has my email and I have his. So you can email me those witnesses and I'll amend my witness list as well, Mr. Williams, so you'll know who mine are as well.
Okay.
All right. All right. So it's at 9:30 a.m. We'll start to get that jury picked on Monday. Oh, and there's also, all right. So now I have a whole slew of officers who are checked in. Officers, this is a jury trial. So it's an in-person jury trial on Monday. In-person jury trial on Monday, 9:30 a.m. at courtroom 337 at 36th District Court this Monday. And once we get the jury all sworn in, then we will proceed with testimony that day, hopefully in the afternoon. Anything else for you, Mr. Williams? I know I'm glad to hear y'all been talking back and forth through email so that we can make sure we're ready to push forward on Monday. Anything else you want to say for the record, Mr. Williams?
No, that'll be it.
Okay. All right. Attorney Mason, do you have anything for the record?
I just want to get a tally of my officers who are present today, just to make sure. I've got Officer Nunley, Officer Bush, Officer Evans, Officer Faison. Nunley. I'm sorry, I said Nunley, Evans, Bush, McCree. Anybody I'm missing? Okay. And Mr. Williams, I will amend my witness list for you, and I'll email that over to you.
Okay.
Okay. All right. Well, Well, then that is the remaining tickets. Are we
We all set?
with those, Attorney Mason, or no? Today, or are we waiting until Monday?
Yeah, any officers that are not here today, Your Honor, we can dispense with those tickets.
I appreciate that. So that is a few tickets. That's gonna be ticket number SP 1283889, SP 1283888, SP 1411848, and SX 2454328. Those officers did not appear today. I know it's just the final pretrial, so I'll just put that. I won't necessarily mark them absent.
What
tickets remain, Mr. Williams? Okay, let me tell you. You ready?
Yeah.
Okay, so you have a drive unregistered, untitled motor vehicle and drove while unlicensed, and a no proof of insurance. That's one officer. The next officers are open alcohol driver, tinted windows, no seat belt, no driver's license, no insurance, untitled motor vehicle. And then the final officer is going to be drive unregistered motor vehicle, no insurance, no license ever acquired, and tinted windows. Okay.
And Your Honor, if I may interject, since he does have an email, I can copy those tickets and email them over to him so that he can have them. I'll come down and get those. And I will email those tickets over to you, Mr. Williams.
Okay.
So that way you
for
can see what
the
the
record,
tickets
are we able to argue these matters right now, or are we going to trial?
You said you want to have a trial. What you want to argue?
Yeah,
You
but
want
I'm
to talk
saying,
to
like,
Attorney Mason?
What was that?
I said you want to talk to Attorney Mason just briefly in a breakout room and see if y'all can resolve any of the tickets.
Well, we was just emailing, and I don't know if it meant anything to her, so that's why I'm willing to just take it to trial. And
well, because you can't say I just want you to dismiss it because I'm not a citizen. That's not gonna work. Or I just want you to
no,
dismiss
that's not it. I got laws stating that all this is frivolous, but I'm saying, can we argue this right now, or do we?
A lot of people will say the laws are frivolous. Well, yes, if you have some argument that you would like to make, you can make it that way. I can rule, and that way we can go to, if we're going to move forward to trial, we can go to trial. 1 second, though, off the record, just for one moment. Christopher Williams, can you hear me? Because Attorney Bynick or Attorney Erane, he's been trying to sign on. He's on his phone. I'm trying to get him to mute *6 so someone can talk to him. *6, sir. *6. Christopher Williams, hit *6 on your phone. *6, sir. You need.
Your Honor?
Yes, Attorney Soroki.
Yeah, if you like, I could speak to Mr. Timothy Williams in a breakout room for a few minutes, explain the legal system to him.
Yes, can you?
No, sir.
Do you want to make your argument first, Mr. Williams, or do you want Attorney Soroki? He wants to give you a little feedback. That way you'll be prepared for Monday's trial. No? All right. He doesn't want it, Attorney Soroki. Thank you, though. I appreciate you.
Okay, very good.
Okay. All right. We're going to try and call that gentleman who called in the meantime. Back on the record in the matter of the people versus Timothy Williams. Can I have appearances? First, Attorney Mason, then Mr. Williams.
For the record, Your Honor, Chiku Mason, City of Detroit, 43471.
All right. Mr. Williams.
Yes, Timothy before the court, here by special appearance. As a state citizen, not a U.S. citizen.
Okay. Changes every time. All right, you want to make a motion or you want to make an argument as to these tickets? You can go ahead at this time, Mr. Williams.
Okay, for the record, hold on. For the record, Shapiro versus Thompson states that all citizens must be free to travel throughout the United States, uninhibited by statutes, rules, or regulations, which unreasonable burden or restrict movement. Did you get that?
I'm listening. I'm just writing down. You see, I got my notepad.
Okay.
I'm writing down
Okay.
notes.
And then Murdoch versus Pennsylvania, the Supreme Court decided that a state cannot arbitrarily or erroneously convert a secure liberty, in this case, the secure right to travel, into a privilege and charge of or issue a hold on. A state can't arbitrarily or erroneously convert a secure liberty into a privilege and issue a license and a fee for it, meaning we don't need license or insurance to travel throughout the land. And Murdoch versus Pennsylvania states no state convert secure liberty to a privilege. No, Shuttlesworth versus Pennsylvania. No, Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity if you happen to have a license. And back to Murdoch versus Pennsylvania, no state may convert a secure liberty into a privilege. So no state has a right to require you to have a license. Hold on.
Okay, so that's your argument as far as no state can force you to have a license.
Require.
Because it's a constitutional right to travel.
Which is our First Amendment.
Travel. Okay. You know, security
Murdoch versus Pennsylvania.
He was in prison arguing about the vaccination. You know, that's part of what Shapiro versus Thompson was talking about, right?
No.
Back to the Zoom call.
Shapiro versus Thompson.
Yes. If I'm looking at the right one, you talking about Shapiro versus Thompson, Sergeant Thompson?
Shapiro versus Thompson.
Shapiro Rowland?
Shapiro. Shapiro versus Thompson.
You're not feeling.
And then Murdoch versus Pennsylvania states that no state can convert a secure liberty into a privilege.
Hello.
Hello. Is this you, Mr. Christopher Williams?
Yes, ma'am.
Okay. Let me put you into a breakout room so that you can speak with an attorney about your case today.
Yes, ma'am.
Put them in breakout room number 5. Attorney Binick, if you don't mind, or Attorney Soroki, either one.
I'll take him. That's fine. Let's see.
Okay. She wouldn't do.
She already beat me. Okay.
Yeah.
Judge, if I can put Christopher Bush in a breakout room, talk to him right quick. Or
You can. I'm reading this case. So this right to travel was about a welfare case, Mr. Williams, where she wanted to go to a different state. And they told her that because she didn't have established residency in that she was going to be denied services.
Right, and that violated her.
Right, because it's talking
right
about services. She needed to take care of her child. She was 19 and she was pregnant.
But you avoiding the facts of the case. Even though that she filed a lawsuit against the state for denying her privileges, but the Supreme Court ruled that the Supreme Court ruled that can't happen because that also be violating her right to travel throughout the states, throughout the land.
Receive the benefits that she needs in order to take care of herself and her child.
Yes, but you're missing the argument that the Supreme Court has stated. That'll be violating her First Amendment right: life, liberty, and pursuit of happiness. Travel. You see that ruling? I don't want you to miss that fact. That's what they ruled.
They said the closest the Supreme Court has come to overturning Shapiro Thomas was in 1995 with Anderson versus Green, California Welfare and Interstate Code annotated section instituted a 1-year residency requirement for welfare aid, violating Shapiro versus Thompson. Both lower courts in California affirmed that violated Shapiro versus Thompson and granted an injunction. I'm sorry. Due to the procedural issue, California's residency requirement never went into effect, creating no justifiable controversy action and no actual issuance for the court to rule on. Whether they receive a waiver from the Secretary of Health or Human Services to set aside Shapiro versus Thompson, making the residency requirement pseudo-legal, the waiver was challenged again, and it's holding that the state court and the Secretary of HHS had not adequately considered public comment on the issues. So this just talks solely about, even talks about the social impact. The social impact and the legal impact is that you can go different places, and we as the governments of each state still have a requirement to take care of those citizens within our state. This is about welfare. Yeah, this is about the welfare system and the ability for people. You cannot stop people from traveling. I don't see anything in here about a driver's license.
Look, the decision of the court.
Right, she has the right to go places.
Look, the court reaffirmed the right to travel under the 14th Amendment Privilege and Immunities Clause in Suez versus Roe. So they conferred it to another case. But the conclusion of the case like that would be violating her right to travel. It can have something to do with the welfare, but it's violating her right to travel.
It's all about that. Because the reason why we can't prohibit her from being able to travel or to go to another state is because then they're saying once she gets to that state, she has to establish some type of residency. And what they're saying is that if she doesn't have that residency, she wouldn't get the services needed. And so they're saying you can't say, oh, you can't go to this state and not get the stuff that you need to take care of yourself and your family just because you're not. I can't stop her. I can't say you can't move to this state and then we're going to block everything. I can't do that. Right. This is not about a license.
Which will violate the right to travel.
No.
That was the decision of the court. I'm not making that up.
You aren't, but you're not understanding what their decision was based on. Yes, you have the right to travel, but this is concerning services.
So if I chose to carry a weapon, I will be bearing arms.
If you
But
chose to
y'all
carry a
call it,
weapon in the state of in Illinois, that's an automatic. You're not allowed to carry weapons at all in the state of Illinois unless you're a law enforcement officer.
I'm talking
So
about
if you
state of
traveled
Michigan.
over the state lines and you went to Illinois and you tried to carry a gun, they would tell you no.
But that's irrelevant, Your Honor. We're talking about the state of Michigan. I have a right to bear arms, but you will call it receiving and
Exactly.
concealing. But the
Well,
Constitution of Michigan states that I can bear arms, but we're
because
making
once
something
again, and
else.
we had this conversation already, the states can make stuff more, the localities can make stuff, they can, and it's a state law anyways, but they can be harsher than the US Constitution, but they can do something that would take away from the US Constitution. So they're not taking away your right to bear arms, they're just putting parameters around that right. And recently it was challenged at the Court of Appeals when someone tried to say that the people have the right to bear arms and that seeing a bulge or doing stuff like that didn't equate to it. And the Court of Appeals has said and ruled that does give probable cause for an officer to ask about whether or not they have the licensing, because the state has determined that they need to have the licensing. So if the state determines that there needs to be a certain licensing in place and that rule or that is violated, then that has to go forward.
But that's kind of irrelevant.
Okay.
And like Murdoch versus Pennsylvania, say no state can convert a secured liberty into a privilege. Our secured liberty, First Amendment, is the right to life, liberty, and pursuit of happiness.
Mm-hmm.
Right to travel throughout the United States of America.
Right.
Freely and unencumbered. We're not causing harm to anybody. We just obeying the constitutional rights. Exercising our constitutional rights, which is the court is here to help protect them. I'm relying on the constitutional rights. I'm not just out here willfully nilly, like United States versus Bishop.
But you are, because you're only taking the part that you want to be applied to you. So you are out here willy-nilly. Because if you were following, if you were following everything, you would want to follow everything and all the rules that were put into place. So all that
I'm following laws, not
following what you want to follow. And that's no. We talked about how that leads to anarchy. People can't do whatever they want to do. They say that I can follow only this. That's like me coming one day and saying, I want to practice law and I want to be a judge, and I haven't gone through any of the things to become a judge. That's not how it works.
I see how you
put it. I can't sit up here with a fake P number. They wouldn't let me do that.
I see how you put it, but that's not true. What about Title 18 USC Section 241?
Mr. Williams, do you want a trial on Monday or not? You can't argue this stuff to the jury.
Yeah, I want to go to trial, but I can't.
Okay. You can't argue this stuff to the jury. You can argue that maybe something, making sure that they didn't check the things, like you have to follow the law. I have to treat you as an attorney in that place on Monday. So I have to treat that you know how to practice and go about the way of law. And these different things, like you can't just give the jury cases and stuff like that. That's not what it's going to be about. And you'll most likely end up with objections that I'll have to sustain, because it's going to be talking about the facts of these particular cases where the officers came today to show up. So it has to stick to those things about what the officers came to argue about, or what Attorney Mason will make the argument for and officers came to testify about.
What are they testifying about?
About these different stops.
Which is unlawful.
Different tickets. Okay. Well, I gave you plenty of time to write a motion about unlawful, and you did not want to.
So now we're here. I gave you affidavits stating the facts, what you needed, and
exactly. And the facts are to be argued before a jury. If they differ from these facts that on the tickets, we're here to talk about these tickets. I've already made my ruling long ago that they had the right to stop, and that these tickets are the tickets for which they wrote them for.
Yes, they have a right to stop persons, but I'm not a person. I'm a human being. I have no contract with the Secretary of State. I'm traveling. I'm not driving. I'm not driving for gain or profit. I'm going to point A to point B, not violating nobody's rights. I'm just traveling freely, like I'm exercising my constitutional rights. Like Title 18 USC, Section 241. Can you look that up?
I let you have a whole hour of time to discuss all of these previously, Mr. Williams. We talked about all of these, and at the end, I made the ruling that the court did have jurisdiction and that the officers could write tickets.
You haven't explained jurisdiction.
I don't have to explain anything. It's not my job to explain it.
But you said you did explain, but you didn't.
But I said I allowed you to explain it. Do you need to pull it up on YouTube?
But the burden is on the prosecutor.
Right, not on me. I'm the court. I just call balls and strikes.
And the prosecutor cannot state how she has jurisdiction.
Okay, Attorney Mason, do you want to state how you have jurisdiction over these matters?
Statute provides us with the jurisdiction over this matter. The statutes and the laws of the court provide us the jurisdiction over these matters.
That's subject.
I am empowered by the state. I am empowered by my bar card, which has been submitted to the state of Michigan. I'm empowered by the city of Detroit.
That she still not stating. I gotta object to that because she's not stating how she has jurisdiction over.
She's telling you it's by the statutes. The statutes that were given.
Statutes is not law.
Okay.
I'm obeying by the law.
So you want us to call them laws? Laws are statutes. They're the same thing. It's just a fancy way of saying laws. Statutes are just a fancy way of saying laws.
Statutes are persuasive. Laws are mandatory.
These are laws. Okay, statutes are laws. That's just a fancy way of saying laws.
Yeah, they derive from the law.
At this point, Your Honor, I'm going to
rules and regulations.
I'm going to just make a motion that these matters have already been resolved. That the court has previously stated that the trial was set forth regarding the facts of the incidents that have arisen, and that the witnesses will testify only to the facts regarding the tickets.
What are the facts?
The facts are the things on the ticket. So you have to research the law and find out exactly what each one is to show.
According to Michigan Vehicle Code 257-744A, police officers knowingly make a false statement on the citation is unlawful.
Okay.
I travel with a passport. My ID been canceled since 2018, so none of that is true.
Just because you cancel your ID, and this is the last argument for today, and then we're just gonna have trial on Monday. Just because you cancel your ID doesn't mean now you have the right to drive in the state of Michigan. That's not the law of this state. When you avail yourselves of the roads, the lights, the streets, the anything. Once you take part on those items, then you automatically allow yourself to avail yourself to any laws that are being taken place, any statutes that are being taken place, any codes that are taking place. All of those now become active, whether you want them to or not. There's no, I don't want them to.
They become active when you agree to the stipulations.
You don't have to agree. It does not say that. We have stuff called strict liability crimes. And those are crimes that automatically kick into place whether you agree for them or not. And that's what these are. Whether you agree or not, they are things that must happen. So
I agree that certain people, I agree.
9:30. I'll see everybody at 9:30. Listen, either you're gonna take care of these things.
Certain persons need to be governed, but everybody is not to be governed. Certain people know how to govern ourselves. So
that's right.
Judge, I'll come down and pick up the tickets and copy them.
Okay. Thank you. That concludes this hearing.
So we all set?
Yes. I'll see you Monday at 9:30 in person for your trial. Okay?
All right.
Jury trial. All right.
I'm not threatening you. Say one more word and that's 30 days. 30 days.